Okay.
All right, we're live. What's up, guys? Welcome to another episode of Trent Talks. Today we have Angela Langlotz. Did I say that right?
Yes, you did. Thank you.
I did. I'm proud of myself.
You should be.
But Angela she's a trademark and an IP attorney. Is that the right way to say it?
Yeah, I do trademarks and copyrights and licensing. Intellectual property encompasses trademarks, licensing, trade dress, patents, but I don't do patents. I keep myself very busy doing helping entrepreneurs identify, protect, defend, monetize their very important brands and creative works.
Well, this will be fun because I've already got a handful of questions. And for the record, Angela, I made a point. She didn't get any prep work at all on this.
Hey, I know my
So
stuff.
it's going to be fun.
I need no prep work.
So obviously we just connected through a series of events that just kind of put us in connection, which was actually really cool. It was a fun dynamic of how we connected. But I think that the most interesting part is it's very challenging to find attorneys who are super familiar with the online space. And that's what's different is you're very familiar with the online. Now you do a lot of brick and mortar, I know as well, but you're very familiar with the online space and whether it's digital marketing, affiliate marketing, kind of all of the above and how that whole process changes the aspect of what your trademark and copyright and what all that means and how it plays out in, I'm assuming, in court and everything else.
Well, I don't litigate in court. I have people that I send that to, but I do litigate before the Trademark Trial and Appeal Board. The good news is most things don't actually go to court.
Right.
Most things are settled long before that.
Nobody really wants generally to go that far.
No. I mean, sometimes people call me and they're like, yeah, I want to sue somebody. And I'm like, wait a minute. I really don't think you want to go there because here's how much it's going to cost. And when they find out the jaw-dropping investment that it takes to actually sue somebody in federal court or defend something in federal court, they adopt a more reasonable position and we figure out how to solve their problem without need for legal intervention.
Well, I'll say that it's interesting you say that because no, I don't want to say who the company is, but I had a conversation with an owner of a company, and they started their company first, and then the name was, I'll say XYZ, right?
Yeah.
I know it's the best way. Please. We just go letters. They were XYZ.
Right.
And then the other company after them was like XZY.
Yeah.
Right. And both companies did well. Their company was doing like 15, 20 million a year in revenue. And then the company after them was up to like 4 or 5 million. And they got to the point where there was like this big, like, whoa, you're like sounding like us. That's not cool. We can't have that. And my thought was naturally they're going to go to litigation. It's going to go to trial. And it didn't. There was an arrangement. This name was bought by this company and there was X amount of dollars. And even with the dollar amount that they said, and it was into millions to have that name or whatever, I was shocked that they were settling there. And then he explained to me, he's like, yeah, but you don't understand. We have two big companies. The prospect of how much is actually probably going to cost us to take that all through the whole process and appeals and blah, blah, blah. He's like, it just is not worth it.
Oh, it's totally
interesting. You said the same thing.
Yeah. I mean, everybody's, everybody's bold when they're behind the keyboard. Everyone's bold until they know how much litigation is going to end up costing them. But, one of the reasons why entrepreneurs should register their trademarks is because it actually gives them a better legal posture when there are these sorts of conflicts. If you say, listen, we own trademark registration number 54327. I just made that up. And
I'm looking it up right now. No,
don't. I'm just making stuff up over here. And we registered it on this date. And our date of first use goes back to this date. They have a whole bunch of legal presumptions in their favor. And that means that there's a whole bunch of stuff that they don't need to prove in court. Now, every time I say prove in court, just think this, okay? Ooh, you can't see what I'm doing here. I'm making the the dollars. I'm rubbing my fingers together.
Every time you prove it in court.
Every time you prove it, think about this. Okay, this is what proving something means in court. It means that you are going to have to prove. So if you have the legal presumptions in your favor as the trademark owner of record, the other side is going to have to come up with proof. Think this, okay, proof. This is what proof is, money. You're going to have to prove a whole bunch of stuff, and that always costs money. So I recommend, whenever possible, to nail down your trademark rights in the record, because in the event of a conflict, it's going to cost you much less to litigate that than it otherwise would if you didn't have a registration. Additionally, you have a much better posture when you go in and ask somebody to stop. When you don't have a trademark registration, all you get to say is a wimpy, hey, I was using that first. But when you have a registration, then you say, listen, I have registration number 54327. Don't look that one up either. Like I said, I'm just making stuff up over here. Then it makes the other side take their feet off their desk and go, whoa, wait, when did we start using this? Oh my gosh, maybe we shouldn't have sent that cease and desist letter before we actually checked what their date of first use was. This was probably a big mistake, right? Because once you send that cease and desist letter and once you light up the other side, you better make darn sure that you were the first user, because if you're wrong, now you're poking the bear. And the bear is going to come back to you and they're going to say, no, actually, we were the first user. Here's our trademark registration. And we want you to stop.
Yeah.
We want you to stop. You know, we were using it first. Here's our proof. You know, here's the Wayback Machine. I love the Wayback Machine. You know, here's the Wayback Machine, and here's proof that we were using it first. And then, you know, the other side's kind of grabbing their fanny and going, oh my gosh, what do we do now?
Yeah. You know? Well, I think the big hurdle and the concern for most entrepreneurs, especially if they're starting out, is they looking at the cost. They're thinking, oh my goodness, well, I just started my company, but like, for example, we're bootstrapping, or we're early on where we're just barely getting profitable. I mean, we know that most businesses, when they first start, aren't profitable generally until year 2 or 3.
Oh, yeah.
And so there's that process of like, what's the right time to file for IP trademarks or copyrights? Like, what's the right time to do that? And I feel like the answer is going to be as soon as possible.
Yeah.
But that's the dynamic, is the money versus when you can swing it.
And look, I get it, right? I get it. As a small business owner myself, I understand that. So you have to take a calculated risk. How likely is it that someone is going to choose a mark that is similar to yours for your goods or related goods? And this, Trent, is where people make a lot of mistakes. They go, oh, well, we just did a quick and dirty search. You know, we went into the trademark database and we searched the mark that we want to use, and no one's using it. And that's where people make their biggest mistake. They say, oh, we didn't find the exact mark and we didn't find it for our goods. So we're cool, right? And people don't realize that other people's trademark rights extend beyond their exact mark and beyond their exact goods to encompass related goods and anything that would cause consumer confusion. And there's
that's
a whole bunch
the key
of
word that people forget.
Yes.
If it will cause confusion, that's where your word mark or the actual logo, like trademarking, comes in, and that's a big deal.
Yeah. And I see this a lot more with word marks than with design marks, also called logo marks, just because the nature of a design mark is that they're usually pretty different, unless you're trying to be naughty and like play off someone else's mark. You know, logo marks tend to be different from one another, right. But I have a, well, I'll tell horror stories later, but that's
we'll make a note to get to a few of those.
Yeah. I have a whole bunch of those actually, but the real issue is that it's pretty easy to infringe and people don't know where the parameters are, right? Like people say, well, I put an S on the end, so it's not the same. Sorry, it's the same. Okay, the plural is not different from the singular. Or, oh, their mark is X and my mark is YXY for the same goods. It's like, no, that doesn't work either, because you can't you can't use the entirety of somebody else's mark in your mark if your goods are related. And people are very confused about what related goods are. It means something different in trademark land than it does in every other place. For example,
quick question on that before we go.
Sorry.
So you talked about encompassing someone else's mark.
Yes.
Okay. So I'm going to talk to a previous company I had, almost 10 years ago now. We had an online news source, and the name of our company was, we covered a specific XYZ company, and we were in a specific industry, and ours was, I'm trying to think of the right way to say it without giving too much info. I'll say ours was super duper XYZ news source. Right.
Yeah.
And what was interesting is we ended up getting a cease and desist from XYZ. Like, hey, you can't say that, they're us. And we had to go through, and there was this aspect of, oh man, I wish I could remember it. All of a sudden my brain's not fully functioning, but there was some concept of us saying that I had a buddy of mine who was an attorney at the time handle it for me. And he said there was something about, if I have to use their name to be able to describe what I'm doing, then that's allowed.
Yeah.
Along those lines. I mean, do you follow what I'm saying?
Yeah.
Because I think that's something where there's a huge ton of confusion. I mean, I think in the ClickFunnels industry, we're familiar with ClickFunnels.
Oh yeah.
Like a lot of people talk about ClickFunnels and they say, oh, well, it's the ClickFunnels this or that. And ClickFunnels are saying, no, we don't want you to use ClickFunnels in your name. But I don't understand that from a legal standpoint, how that all functions.
Okay. Well,
am I diving in too big of a rabbit hole?
let's parse this.
Sure.
There's a couple different issues here. One issue is, if you have a mark that has descriptive elements in it, you can't prevent other people from using that descriptive element. Let's say, for example, that my mark is Flowers Shoe Company, right?
Okay.
So the descriptive part of the mark, if I'm selling shoes, is Shoe Company, because I'm just describing a company that sells shoes. Do you follow?
I do.
So when we register that as a trademark, we're going to be required to disclaim the exclusive right to use the word shoes and the word or shoe and the word company apart from the mark as shown. So we can stop other people from using Flowers Shoe Company, but we can't stop anyone else from using something else, Shoe Company. Do you follow?
Gotcha.
Okay.
Right.
But if somebody else wants to have a brand called Flowers and they want to sell clothing under that brand, that's not going to fly, because, or actually it may, depending on the record. This is a bad example. Let me give another example. So let's say that I have a mark, it's Flower, and it's for cosmetics.
Okay. And
someone else, you sell sunglasses, and your mark is Flower, like just the name Flower.
Right.
And FLOWER, not the kind of flour that you make bread with.
Sure.
Your mark would be refused registration because, did I say cosmetics? What was the?
Yes.
Okay. So because cosmetics and sunglasses are actually related goods in trademark land.
Interesting.
Okay. And the reason why they're related is because we tend to see them coming from the same source, right? For example, Chanel makes cosmetics and sunglasses. Tom Ford makes cosmetics and sunglasses.
So in our industry, for example,
makes sunglasses.
If you were to have someone file a trademark or a copyright, which one is it? Trademark?
Trademark.
Okay, so if they filed a trademark and they're a web design company, you couldn't go file a similar trademark and say, well, I'm an advertising agency, because those are then related, because a lot of people who do web design then do advertising and vice versa. Even though the industries are separate, there is a lot of cross in between the two.
They are related, right?
Interesting.
And here's the other thing too. Let's say you said, oh, okay, I can't use FLOWER for my sunglass company because somebody already has FLOWER for cosmetics. So I'm going to call my sunglass company flour, but I'm going to spell it Flour.
You are
right?
like the actual cooking ingredient.
Right. So I'm going to call it flour. That's a ridiculous mark for sunglasses, but play along. That would actually be an infringement as well.
Because of the confusion when you're saying it.
Exactly. So we look at the overall commercial impression that the mark makes on the consumer. And when you say flour, the plant, and flour, the
cooking
ingredient, they sound the same. So
right.
you're not going to be able
totally.
to do that. If you wanted to have a brand, you said, okay, somebody else has flour. I'm going to call mine farina, right? Farina means flour in Italian. I'm going to call my sunglasses farina and try to get around it. Well, you can't do that either because there's this thing.
So it extends through languages as well.
It extends through languages, exactly. People make all kinds of mistakes with this because they just don't realize where the box is drawn, right?
So it really doesn't even matter if someone does something crazy.
Crazy,
like if they want to do like
crazy with a K is still crazy. That's what I like to say. You can spell it with a C, you can spell it with a K. It's still crazy.
Interesting. For example, so like crazy glue.
Yeah.
K-R-A-Z-Y. You couldn't do a C-R-A-Z-Y glue.
Nope.
Because
it's crazy.
Interesting. All right. So now what's the difference when you talk about now trademark and then people go into copyright?
Yeah, people get those mixed up all the time. It's really.
I'll admit I'm guilty of that. I do that. Okay. That one messes with me.
They actually protect different aspects of intellectual property. So copyright is for anything that's creative. If it's useful, you can't protect it with a copyright. Okay, you have to go with a patent. So patents protect things that are new and useful.
Gotcha.
Copyrights protect the creative aspect of any work. For example, let's say that you write a song. Copyright would actually protect the written musical score, it would protect the lyrics, and it would protect the performance of that song.
Interesting.
That is all subject to copyright. So copyright covers creative works reduced to a tangible medium of expression, right? So that's what copyright protects. Trademarks protect your exclusive right to use a certain source identifier. I'll talk about what a source is in a second. Okay. A certain source identifier in commerce. And there's a little bit of overlap because you can actually have a logo, the creative aspect of which is protected by copyright. And when you apply that logo to certain goods or services, and you have a trademark registration, you actually have the exclusive right to use that in interstate commerce. So it's a little bit confusing sometimes.
Interesting.
There is some overlap. There's also design patents, which protect designs. And there's a little bit of overlap between trademarks and design patents. It's a little bit confusing, but it's too much to go into here.
But so is it a fair way to simplify, like for the average entrepreneur, say, for example, so the trademark is more of your branding and your recognition who you are.
Yes.
The copyright is the creative that you put out. And then your actual patent work would be anything that you're actually, I don't want to use creative, anything that you're designing or building that actually has a functional use.
There you go. There you go. Perfect. You have it perfectly. Let's talk about what a source is. I said a trademark is a source identifier. A source identifier links that word, phrase, whatever, logo, design that you're protecting to the company that's producing the goods. For example, when we see the swoosh, we know who makes those shoes, right?
Right.
We know it's Nike.
It's Nike.
When we see the three stripes, we know that shoe is made by Adidas. We know this because we're very familiar with those brands. So in order for something to function as a trademark, it must serve as a source identifier. If you don't have a source to identify, you can't have trademark rights. Like people will say to me, oh, well, I have trademark rights over this URL. I have the URL, therefore I have trademark rights. And I'm like, well, no, you don't. If you're not selling anything and you're not applying the mark to those goods and selling them or offering them for sale in commerce, goods or services, you don't have any trademark rights. Because remember, Trent, the whole point of a trademark is to identify your goods and services and distinguish them from other people's goods.
From someone else. Right.
Yeah. And if you're not selling any goods and services, then you have no reason to have a trademark.
True.
Simple.
Okay. So this is another concept that you hear about. And I don't fully understand what it means. And it kind of comes up. You hear people talk about cyber squatting online. What is cyber squatting?
Well, cyber squatting is when person A gets a URL for person B's trademark and then tries to basically blackmail them into getting their rights. And there are certain circumstances under which you can fix this and certain circumstances under which you cannot. So if you had trademark rights before the naughty person started, bought your URL and started squatting on it, then you can do something about that. You can force actually the transfer of that domain.
Interesting.
Yeah, there's a whole process for that. It's called UDIRP, Uniform Domain Rights Protection. I forget what it stands for, but yeah, there's a whole process for that. But if they acquired your domain and then you got the trademark, you don't have any rights, because what you have to prove doing—
You could just prevent them from putting something on there.
Well,
is that correct?
Yeah, I have secrets for doing. I have secrets for drawing the mustache on that Mona Lisa. My clients are privy to those, but yeah, there's a way. There's a way that you can do that. But it's too good to share. Sorry.
Fair enough.
I don't want to empower the domain name squatters who might be lurking here. So
fair, and I'm good with that.
I want to protect everybody. So yeah, you can actually force the transfer of that domain if they're squatting on it and they acquired it after you registered your trademark, because it's presumed that the only reason why they got the domain, because they're not using it for anything, the only reason why they got the domain was so that they could blackmail.
They could try and blackmail you to get money out of you.
Oh, like they'll say, oh, I'm going to put porn on this. Which of course is distressing, for a business owner to have their name associated with that. So, yeah, so that's why
interesting.
I have methods to combat that.
So that's interesting though. So, but that comes back to another reason then that as soon as you're able to financially, where it makes sense to get out and get whether it's your logo mark, your design mark, trademarked, as well as your word mark and everything else, so that you do have that protection of, hey, look, if someone decides they want to, as I grow, someone tries to hose me, no, can't really do that.
Yeah, I do recommend that. And if you're looking to get the most bang for the buck, I tell my clients, look, let's register the word mark. If you have a word mark, some companies don't have a word mark, like Prince, he turned himself into a symbol, right?
Yeah.
To quote the Eminem song. But yeah, gosh, I mean, I know that it's an investment at the outset, but you're going to save yourself so much pain down the road. You really should do it as soon as you can. And yeah, you can hire one of these cheap trademark registration services like LegalZoom or Trademarkia. But you're probably going to come see me later when you do that, because they're going to screw it up. So I like to tell clients, listen, if you're going to hire one of those people, if you're really price sensitive and you want to hire those people, go ahead and don't hire them and just file it yourself, because you'll screw it up just as much as they will.
Interesting.
No, I'm serious. Like, I don't even know why people hire them, because they don't offer the client for that cheap price. They don't really offer them legal advice, and they won't really, like, when somebody hires—
I mean, a lot of times, do they fail to get a full in-depth search in?
Oh yeah, they'll do what I call an exact match search. They go in, they put that exact mark into the
like we talked about in the beginning.
Yeah. And then they go, oh, well, there's no exact match. Let's file it. And then the bad thing is that you don't find out from the trademark examiner about your rejection until like 4 months later, because that's how long it takes we just go into line with every other application, and that's how long it takes to actually get in front of the trademark examiner. So 4 months later, you're going to find out, I
have a problem.
I have a problem. And now, depending on what sorts of admissions were made during the filing of the application, I might not be able to fix it, right? So,
Gotcha.
I mean, you wouldn't hire a guy off the street to give you heart surgery, right?
Of course.
So, I mean, if you care about your business,
agreed. There is still always a concept of you get what you pay for.
Yeah, exactly. It's just like everything else.
I get
And there's
that.
a lot of subtlety to trademark law.
Mm-hmm.
A lot of people think, oh, well, she just goes in and files the application. That's not true at all. I actually go in and do a search, and I look at the record, and I see how close, because you can get closer to somebody else's mark if there are certain things already in the record, right? So if more people are using the mark, we have a lot more leeway. And I've filed, close to 1,000 trademark applications by this point. And so I know where that line is. I know what's going to make the examiner go, oh, okay. And what's going to make the examiner go, I don't think so.
Yeah, I'm not sure about that. Interesting.
Yeah.
Okay. So one other thing I want to talk about, because this comes up a lot, especially with the use of social media and everything else, Instagram specifically.
Yeah.
And there's a big confusion about this. So photos. When people, what are you doing? Resharing on Instagram, and you hear the different stories. Well, I reshared this guy's photo, and then he tried to tell me and demand that I pay him like $1,000 for resharing his photo, but I gave him credit. I credited the photo to him, but he didn't. That kind of thing.
Yeah. Well, you have to go.
What's that kind of situation? How does that play out?
You have to go in and look at the terms of service. Like I know on Facebook, you're actually giving other people the right to share your stuff on Facebook if you put your stuff up on Facebook, and Instagram has similar terms of service. And if you're actually using someone else's photo, but you're crediting them, like you're sharing it, the terms of service explicitly say that that's allowed, but always go back to the terms of service, because when you upload something to a social sharing site, and someone else shares it and tags you and says, this is where I got this. It's really hard to argue that they're stealing your stuff. They're sharing your stuff on the platform that you put it on. If they take it off of your platform and you put it on your blog, that might be an entirely different issue.
Gotcha.
A lot of people, copyright has a lot of subtleties too. Oh my gosh. I mean, and copyright law was written during a time when there wasn't the internet. Okay. So
the internet has changed a lot.
It did change a lot. And there's a lot of things that entrepreneurs do every day. Like they share stuff that isn't theirs. Right. And anytime you do that, you're opening yourself up to allegations of copyright infringement. So, and then there's also this blurry line about what's a derivative work and what isn't. Now, a derivative work has the same rights as the original.
How much has to be changed versus,
Exactly. Like, how much do I have to change to make this my own original creation? Right. I mean, it's just, it just drives me absolutely crazy. And I really think there needs to be some changes, because right now you don't have to put a C, the circle C, on your creations, on your work to say that it's protected by copyright. And so it's really hard to tell what people intend to share and let other people use and what they don't. And what I think Congress ought to do, now this is Congress's job, they need to modify the law. It would be more fair, I think, because the internet is we just share everything, right? Right. We don't know where the line is anymore. I think it would be fair to change the law to say you're not guilty of copyright infringement unless there's a circle C on it and you took it off, or there's a circle C on it and all rights reserved and you shared it anyway. To me, that would be fair, because it's kind of like, I like to say that copyright infringement is kind of like speeding, right? When you get stopped by the cops, they don't ask you, hey, did you know you were speeding? Actually, they probably do because they want to get you to confess.
They want you to say, yes, I was speeding. Yeah.
Because it makes their job easier when they write you the ticket. But knowledge of whether or not you were speeding is not an element of the offense. In other words, the cop doesn't care whether you knew you were speeding or not. He's still going to write you the ticket because you went over the speed limit.
Right.
Same thing with copyright infringement. You don't have to have intent. All you have to do is copy somebody else's stuff, and bingo, you're now guilty of copyright infringement, even though you didn't know. You knew that it wasn't yours, right? Like you knew that it wasn't yours, so there was that. But you didn't know if it was protected or not, but you're still guilty of copyright infringement. And I think that's a little bit unfair.
A little bit, yeah.
I mean, with speed limits, there's a rule book, right?
Even at least there's a sign posted on the side of the street. You know, you don't.
Yeah, there's usually a sign posted. And if there isn't a sign posted, we all know that, hey, in this municipality, 25 miles an hour is the basic speed limit,
right,
unless there's something else posted, right?
Right.
So that's fair. We all know what the rule is. But when creators aren't required to put others on notice of their copyright, it's a little unfair to say, oh, you copied my stuff and now I get damages.
Yeah. Yeah. That's the confusing part. Okay. So let me ask you this.
Yeah.
And we'll throw a disclaimer right now. What we're about to say is not legal advice. These are just two people brainstorming, having conversation.
Yes. Disclaimer. I like to say, unless you paid me, it's not legal advice.
There you go. This is not legal advice. This is us having a dialogue.
There you go.
What are some thoughts and ideas, like, for example, for Instagram, Facebook, that people should just, like, here's a basic checklist of here's what you should think about to avoid falling into that? Is it as simple as just let me credit the source of where I got it from? Or are there other things that I should consider to just basically try and avoid any of that?
Anytime you're on a social media site, Trent, you want to go read the terms of service, right?
I think that's something we've all skipped, except for you.
Yeah. So you want to go read the terms of service. And I'm just kind of curious, like, I want to go see what the Instagram terms of service are. Instagram, I'm Googling this right now. Terms of service. And we'll go back to this in a second. But I really think that people should read the terms of service. Now, these were updated in 2018. Okay, so let's see. Because this, I think, will be really enlightening for people, because that's one of the big things I've seen, the quote unquote horror stories on Instagram, where someone, a photographer, tries to go after somebody else because they shared the photographer's photo. And then at the same time, that person's like, look, I just was sharing your work. It was here. I thought it was a cool picture. Yeah. Okay. How you can't use Instagram. Okay, let me hear. Okay, permissions you give to us. Okay, so as part
we're
of
getting behind the scenes, just so everybody knows right now, we're pulling back the curtain.
We'll pull back the curtain. We're lifting the kimono. So when you upload content to Instagram, you give them a license to use it. Okay, they don't claim ownership. But you hereby, it says, and I'm reading this right from their terms of service, when you share, post, or upload content that is covered by intellectual property rights on or in connection with our service, you hereby grant us, this is Instagram, a non-exclusive, meaning that you're not giving up your rights, but you're granting them to Instagram, okay?
Right.
Royalty-free, transferable, sub-licensable, and that's pretty important, and I'll talk about that in a second, worldwide license to host, use, distribute, modify, run, copy, publicly perform or display, translate, and create derivative works of your content. Okay. You can end this license anytime by deleting your content or account. However, content will continue to appear if you shared it with others and they have not deleted it. Okay. So two
things from my novice mentality that I picked up there. Your only way to sign or end the agreement is by uploading or deleting that photo.
You need to,
and just because you do that, that does not necessarily remove rights for anyone else who may have shared it elsewhere.
You're absolutely right.
Wow.
So that's, Okay, so you're giving them a sub-license. A sub-license is the ability to license it to other people, right?
And that's where our sharing comes in.
Yeah.
That's crazy.
So, I know, right? So you're granting them a license and you're granting them a sub-license, which contemplates, even though it doesn't explicitly say it, that they can license it to other people for the use of other people. Okay. So this whole business, and it doesn't explicitly come out and say, hey, other people can use your stuff. I don't know why they didn't. Maybe that's just a bridge too far.
But the sub-licensing, from an attorney standpoint, that to you just said the sub-licensing says we're using those sub-licenses so that the rest of the members on our platform can share your photo.
Well, it contemplates that. It's not
Fair enough.
but it doesn't explicitly say it. It's not without the realm of possibility. Okay. And if you don't like this license, then you need to delete the content. And if, let's see, what else?
So I'm noticing one thing.
Yeah.
It seems that the responsibility, if you will, is completely different than in this type of situation than from like a criminal court. Criminal court, you're innocent unless they can totally prove you're guilty.
Yeah, there's a different standard.
Here, it's almost the flip. You have to prove that you actually have it, that you actually have the trademark and you've had it protected and
Don't get them mixed up. You'll confuse the viewer.
Yes, you're right. Sorry.
Right here.
We're doing creative now. Correct.
Yeah.
We're doing the creative.
Okay.
So you have to actually then prove that it's copyrighted and prove that in this situation, Instagram's release didn't allow them to do that. It's not like, I would say prove beyond a reasonable doubt. It's not like the flip where you just have to be able to get the judge to think it may have happened. You have to actually be able to show that it happened. Is that a fair statement?
Are you talking about I'm pursuing somebody for violating my copyright?
Correct.
Okay. When you've uploaded it to a sharing site, you have many fewer rights over your creation because you've put it up in a public forum. Okay. If
Gotcha.
you put it on your website, that's different. So if you put it on your website and somebody comes and downloads it, that's a whole nother situation. It's completely different. But I was looking at something here. Okay. It doesn't say what other people's rights are to use your content. It only says what their rights are, but you may be giving other people the right to use your content. And I think this agreement actually contemplates that. I'm sorry, I'm wiggling my desk here. Stop it.
No, you're fine. But it contemplates that based on that sub-licensing quote.
Yep. So I'm thinking, you're giving up a lot of rights. So you really don't have the right to, go after somebody for sharing your stuff when you put it up on a site where everyone to see everything, and then they give you credit for it, right? Like,
would you say that's the key thing? Stuff is to not pass it off as your own. If you're sharing Instagram, just make sure that you give the original artist or the original person credit for it.
Yeah. I mean, if you're giving somebody the original creator credit and you're if you're sharing it from their account, like the best way to do it is to just share it from their account, right? Because
do a complete repost.
Exactly. Yeah. I don't know if I'd call it a repost. I would call it a share. Like, don't download it and upload it and give them credit. Gotcha. Share from their account, because that's really what we're supposed to be doing, right? We're supposed to be sharing. If you download it and then upload it again, that's a little fuzzier.
Fair enough. I was thinking the app. Sorry, I was thinking I have an app on my phone, for example, for Instagram. It's called Repost.
Yeah.
And I hit that, and it actually takes the photo and puts their name at the bottom of it. Says at whatever the Instagram username is, and then shares the photo with their name like embedded on the bottom of it.
Oh, that's nice.
That's why I said repost, but I get what you're saying. If you're sharing it and not changing anything, you're protecting yourself in what would be the best way possible.
Yes. Yes, I think so. Like when you do the repost, even though you're watermarking it, and I hear you, I don't think that what you're doing is really condemnable for either from a legal standpoint or a moral standpoint. Like you're obviously giving the creator credit, but when you when you just repost it and you don't share it,
there's a difference in the algorithm as well, and that's something that may be considered in addition.
Yeah, so you're really not using the platform as Instagram intended, right? Like if somebody uploads their stuff to Instagram and they know that Instagram is a photo sharing site and that the platform exists to have people share photos and that it's possible using Instagram's own terms of service to share and own features that we're all aware of to share photos from other people's account to your account. It's hard to argue from a copyright standpoint that that is copyright infringement.
Gotcha.
Because you're using the platform in the manner it was intended and you're sharing somebody else's stuff that they uploaded to be shared.
Right.
Right? Like if you don't want to share it, that's cool. It's a free country, but don't put it on Instagram.
But don't upload it. Right. It makes sense. And I get what you're saying too about using it. The more closely you can use the platform in exactly the way it was intended, the more protected you're going to be by that platform's terms of service.
Exactly. Exactly.
Gotcha.
So to be safe, like what you're doing is probably not
on a scale of 1 to 10 from safety, it's probably about an 8 or a 9.
Yeah.
It's not as safe as possible.
Because you are giving them credit. It's not like you're stealing their stuff, but you're also not making it easy for people to find the source. They can't
I'm not giving them the full benefit of the share.
Exactly.
Yeah, that makes sense.
You know what I'm saying? So, be a good human, share it and give them the credit so that people can go back to their account because that's what it's for, right? Like use the platform how it was intended.
Right. And I think a lot of people also, and this is a completely different conversation. A lot of people also forget you don't have to do better in business by I've said this numerous interviews like this, by tearing someone else's building down.
Oh,
just build your own big building.
Yeah.
And they can build theirs right alongside you and everybody wins.
Yeah, exactly. Like people have this weird concept of scarcity, and I honestly think that we're each more attractive as personalities when we do our own stuff. I mean, sometimes we bring in other people's stuff because we think it's cool and we want to share it with our audience, right? But we're not ripping off the other people's stuff. We're going, hey, audience, like I share stuff on LinkedIn from other trademark law firms because I think it's interesting and I think it benefits my audience on LinkedIn. I don't just share my own stuff. I aggregate other people's stuff too and share it because I think it's interesting. And it also gives me room to make more content because I can't put my own spin on it or commentary,
And the bottom line is the people that follow you because they connect with you. Right.
They're following me not just because I give them cool information, but because they like, I do a lot of video work for people who don't know, for people who've been living under an entrepreneurial rock. If you haven't seen my videos, I don't know why, because I'm kind of everywhere. No, I just like it. I think video is like
you're very consistent, though. I will give you that. You are very consistent in the content that you put out.
Yeah, and I love it. I've been a little bit inconsistent in the last couple of weeks. I had a family illness and a death, so I wasn't, here in Dallas at my desk. I was actually in Oregon with my family, saying goodbye to my grandma, which I was really grateful. Thanks. She was really great, and I was super grateful that my law practice, as flexible as it is, allows me to do that. And isn't that what we all want as entrepreneurs, right? Like,
it's okay. I got to say this with you saying that, because I actually had this conversation. There's a thing going on YouTube about someone who's going to expose how evil marketing is and how the marketing industry is like 1 in 500 people become millionaires. So nobody's successful. And I was talking with I was talking to my cousin. He's in the industry as well about this yesterday. And I looked at him, I said, we were on the phone. I said, you know what's weird is that I don't think that most people in the marketing industry define their success as, I'm a millionaire, so now I'm successful. It's exactly what you just talked about. It's about me having the ability to live my life. And I know this is not like copyright and trademark stuff, but it's about me being able to live my life, run my business. And in your situation, when you have a significant event in your life happen, you can say, look, I'm leaving. I need to go be somewhere else for a little while. And I have the flexibility to do that because I have this business I built.
Yeah. Yeah, exactly. I mean, I was actually contacted by a recruiter last week, and he was like, well, there's this opportunity. They find you on LinkedIn, right?
Of course.
And he's like, well, here's this opportunity and it pays in this range. And I'm like, okay, so here's the deal. Here's my situation. I work at home. This is my home office. This is my bookcase, whatever.
Likewise.
I work at home. Yeah. This is my ceiling fan with the light bulbs, whatever. These are my lights, my studio lights. I said, look, I work at home. I set my own hours. I work in yoga pants and Uggs, unless I'm on camera, and then I put on a dress to make myself look respectable.
My wife would tell you, like, literally, I have a polo on now. It's my, my new logo.
Yep.
He's like, we'll have to talk soon.
I like it. That's a great logo. Have you thought about registering a trademark for that?
There was this attorney that came across my feed. I might have to talk to.
Yeah,
I'll try and track her down.
Somebody who can help you out with that. But anyway.
It's the same thing. I'm in shorts and a t-shirt half the day with just socks. It's nice.
Yeah. And if you want to go out and go to Costco midday when everybody else is slaving away, you get to do that, right?
And it's not crowded.
Anyway, so I told this recruiter, listen, I make XYZ, and I have this great sitch. And he's like, yeah, you ought to keep that.
Yeah, exactly. That's funny.
So anyway, but one of the reasons why entrepreneurs hire me, Trent, is because I get it, right? Like I get
you live the life. You're not the corporate stuffy attorney. You live the life, so you understand what we deal with. I get it.
I get it. And there's absolutely nothing about any of y'all's businesses that you're going to have to explain to me. I know. Right. I know. I already know. I already do it just like you all do. So I'm speaking to the wider audience here. Not
absolutely.
So that's why people hire me, is because I just, I get it. I know what you're doing. I understand the struggles. Okay. And I'm in the trenches with you. And there are so few attorneys who can say that. I mean, most attorneys sit behind a desk all day. They don't know how to build a marketing funnel. They don't even know what a marketing funnel is.
Sure.
And they're just very, they live completely different lives. And
no, I agree totally.
I wouldn't trade my practice for anything. There's just no way I would give this up.
No, I'm going to have people contact you. We're going to talk about that in a second. Now, I want to do one thing though, because this I'm going to make them. We're going to have them contact, but we're going to save till afterwards.
Okay.
The horror stories.
Oh God.
Because we're going to use those as our call, we're going to do sales funnel there. It's our call to action of why they should reach out.
All right.
But so if someone wants to reach out, they want to contact you, what's the best way for them to get a hold of you?
Best way to get a hold of me is by email. I know that sounds a little old fashioned. I mean, you can message me on Facebook, but the best way to get a hold of me, because, Facebook Messenger gets pushed down, and
it does. It bump. Yeah.
And I tell clients, listen, contact me by email, because I actually do read my email, because I've kind of set up a system to like filter out all the crap I don't want to see.
So the ones that come in, I need to read those. Fair enough.
Yeah, exactly. So the ones that come through, I actually do read, because my email inbox isn't clogged up with extraneous stuff. So they can contact me at angela@trademarkdoctor.net. And they can reach me that way. You can also go to trademarkdoctor.net and go to the contact page. If you forget my email address, you can contact me there. And, I'm on Facebook. I'm all over the place.
Yes.
My videos get shared a lot. And then I also have a YouTube channel that has, like over 200 live videos on it talking about trademark law. So I'm a pretty prolific creator. And this is what I love. I love what I do, and I love explaining.
It makes it easier when you do.
Well, it makes it a lot easier for people to hire me, because they kind of know who I am.
Right.
You know, I mean, you see me, you want to go see who I am? Watch the video. This is how I am. You know, this is
you get a very easy understanding of who the person is. Totally.
Yeah, like this is what you get when you hire me. You're not going to get a stuffy attorney who's going to use a bunch of big words. My superpower, I like to say, is taking complex concepts and making them intelligible to the average person. And I like to do that. I'm good at what I do. I don't need to bamboozle my prospective clients or clients with a bunch of big words. I like plain
when
language.
you know your value, you don't need to confuse people.
Exactly.
Simple as that.
Exactly. So,
all right. So here's the sales point. I want your 2 best or worst stories, if you will, of people either not doing it right or people forgetting to.
Yeah. Okay. So here's a good story. This guy was a magician, and I'm not saying anything that I oughtn't. Like, I always keep my clients' secrets.
Right. We know everything is spoken in generalities so that we can't tell who is who.
So this guy was a magician, and he found me on Facebook. He had a magic show on Guam. For those of you who don't know, Guam is part of the Marianas Islands. It's actually a U.S. territory, so it's covered by U.S. trademark law, right?
Interesting.
It's like Puerto Rico and the Virgin Islands are. So trademarks cover all U.S. territories and protectorates. Anyway, so he contacts me, and he didn't register his trademark, even though he was using it. He had a really popular magic show on Guam, and it was super family friendly. And he had a ton of Expedia reviews that were just glowing, and he had a lot invested in his brand, but he didn't bother to register his trademark. So some naughty infringer from New York sees what he's doing, registers the trademark, even though they weren't using it first, comes over and starts a magic show, same name, except his is raunchy, okay? It is like PG-13, sometimes a little bit R, and because it's the exact same name, people start confusing the two. So here's my guy. Wow. He's got his squeaky clean, family-friendly magic show.
Right.
And then there's this other guy, the infringer, who's got the raunchy show, okay? Same name, same territory, okay? My guy is pissed, right? So he comes to me and he says, what can I do? And I'm like, well, we're going to have to file an opposition to this trademark application, right? So we file the opposition, and because my guy doesn't have the money to see the opposition all the way through, because this naughty infringer has hired some big New York law firm. He has a ton of money. We think he was actually funded by somebody else, like a bigger magic company, but we have no way to prove it, right? So basically, he can outspend my client. And so my client ends up settling this out of court, right? Because he doesn't have the money to fight this guy. And he ends up giving up his name for like $10,000. Okay. I was like, are you sure you want to do this? He's like, yes, I can't stand the stress. I just want it to go.
Oh my gosh.
And I'm like, okay, if this is what you want, but my God, I think you're underpricing this. He's like, look, I don't have the money to fight anymore.
It's all the choice is what he's saying. Yeah.
Yeah. I mean, he really felt like he was being, kind of blackmailed. Like, we're going to tie you up in court and take your name anyway. Even though, because now.
Did you want to take your money and the name, or just the name is what he pretty much felt?
They wanted the name. They were like, oh, this is a cool name. He doesn't have it registered as a trademark. Let's just take it. And I felt so frustrated on behalf of my client, but look, I don't work for free either. Right. I just can't, even though I felt really frustrated for him. So he ended up giving up the name. Maybe it was $20,000, but whatever it was far too low considering the goodwill that he had built up over the years in this trademark, but he didn't have a registration. So when you don't have a registration, now you have to go on the offensive, right? If he had had a registration, we could have come to them and said, listen, you have to stop. And, even with a registration, sometimes it's difficult if your infringer gets really entrenched. If your infringer isn't entrenched, then it's easier. So don't wait if you have an infringer, right? So when people don't protect their trademark rights, when you don't register your trademark, it's actually not in the trademark database for the examiner to find and for potential infringers to find. Like,
because the examiner is not going to go research on the internet. Let me see anybody that's ever used this. How long ago did they use it?
They don't. All they do is they look at the trademark database. If there's nothing in the database that's confusingly similar, then the mark is granted issuance.
Wow.
And then you're in the very uncomfortable position of having to assert your ownership over the mark. And it's really, like, I'm doing this again, it's really expensive, right? My client just couldn't afford it. So, I mean, that broke my heart. But like I said, I can't.
You know, it's funny you say that story.
Yeah.
I actually have a colleague that had something similar. He had an actual company name, and they had been using it for 7-8 years. And come to find out, a company in another country had come over here. They only been using it for 2 years and filed a trademark.
Yeah. Well, you know,
and so these guys had to go and they had to fight that. It literally, I remember it took them almost 2 years, about 18, 19 months to get through the process. And it was not cheap.
Oh God. I mean,
and that was even through a very close friend of theirs. So they were getting discount.
Yeah. Well, here's the other thing too. People don't realize this, but foreign trademark registrants, if they've already registered in another country that's covered by what's called the Madrid Protocol, they can actually come into the United States and register a trademark here, even if they haven't used it yet, based on their foreign registration, right? So you can actually have someone come in and register your trademark, even though they've not used it here, and acquire trademark rights that may be better than yours. And if you've not registered yours, you're going to have a hard time, right? Like you may not have, they may not tell you to stop because you already have what's called common law trademark rights. But if you're going to rely on your common law trademark rights at first, and then you try to get a registration later, you're going to be refused registration because of this foreign entity that came in and registered a mark that's maybe similar here in the United States, because they can use their data first use from the trademark registration that they have in a foreign country.
That's crazy.
And vice versa. I'm actually doing a trademark application for a client based on his application here in the United States. We're registering a mark in Switzerland for him.
Interesting.
Yeah. So, I mean, God, look, I get that people don't want to spend the money, but these unregistered trademarks are just a big problem for entrepreneurs.
Is there, and I know sometimes this is like asking how much is a car.
Yeah.
And I'll ask last, you know, it's coming.
Yeah, I know. You want to know how much.
Is there a basic range that someone should say, okay, assuming everything goes super smooth, assuming there's no issues, because obviously all that is variables that can change how everything flows.
Yeah.
But assuming it's as simple as the research, it's the application, the process, is there a rough base ballpark that they can say, this is what I need to plan for?
It's less than $2,000.
Okay.
And depending on how many different types of goods you have in the application, it can be more, but it's less than $2,000. And what that buys you, Trent, is certainty. Okay.
Right.
When you get a trademark registration, it buys you the certainty that you have the legal and exclusive right to use that mark with your goods or related goods. Okay. Mm-hmm. Now, maybe someday are you going to have to defend that against a naughty infringer? You might. Is that going to cost money? Yes, it's going to cost money. But
it costs a lot more if you didn't have it.
Exactly. And when your mark is in the database for people to find, it actually prevents those registrations from issuing. So the trademark examiner, if you're in the database, they're kind of serving as your trademark watchdog. They're going to say, no, we already have one like that. Sorry.
Interesting.
No, right?
So it kind of stops people early on to prevent them from getting to the point where you have to chase it.
Yes. And the trademark database is very, very crowded. Okay. There are literally thousands of trademarks being filed every day. Okay. And I'm not exaggerating that when I say thousands, because, I'll file something on Monday and then I go in on Tuesday and there's, I can see what the serial numbers are. They go sequentially, right? I'm not making that up. So, because everybody wants to do business here. We're a huge market here in the United States, like the biggest economy in the world, except for China, and they don't respect anyone's trademark rights anyway, so who cares?
We don't really count them right now.
Right? We're not going to count China. China's crazy. But, we're the biggest market in the world, and everybody wants to sell to us. So it's really hard these days. It's hard to find a good brand, So if you've got something that you think is really cool, chances are somebody else has probably already thought of it. Sometimes I'm astounded. Someone will tell me, I want to register this for these goods, and I'll go, well, that's probably already taken. And I'll go in and I'll find that it was taken, but then it went abandoned. And I'll be like, well, shut my mouth.
We'll go ahead and take care of this right now.
Oh yeah, we're filing this today, baby, today.
Well, awesome.
So,
Angela, this has been fun, super, super informative. And just remind anybody, if you're at the spot and you missed it earlier, Angela at trademarkdoctor.net.
Yes.
That's the email to use if you have questions, if you want to reach out to Angela, if you're ready to hire her, you want to get your trademark or copyright done. Cough, cough. But thank you for being here. It's been so much fun. I appreciate it.
Oh, well, thanks for having me, Trent. I really feel privileged to be able to talk with you here and share.
I'm sure we'll talk soon.
Yeah.
Thanks, Angela.
Bye.
I really hope you enjoyed and got a lot of value in this video. If you did, make sure you like, subscribe, and comment below. I'm going to be answering all the comments myself. And also, come find me on your favorite social media platform and tell me what else I can help you with.